And hey, everybody, welcome back to the Law and Crime Network. I'm Michel Bryant with you for the afternoon session. You know, when I got ready for this day, I knew we might have a few verdict watches underway, even a death watch, and maybe a third verdict watch in the Delgado case. But hey, what do I know? I had no idea that the case that would be resolved by jury verdict at this point would be the Delgado case. So let's go through everything that's pending and happening here, okay? I want to have my guests join me this afternoon. I got a couple of folks coming in, but first off, I have Julius Collins. He's a criminal defense attorney from Atlanta. Julius, thank you for being here. I appreciate your time. How are you?
I'm good. How about yourself, sir?
Very good. So I've just been chatting about the death penalty and how they carry it out or try to carry it out in South Carolina. What's your take on the practical application that, hey, we'd love to put you to death. The jury said to do it. We can't do it. We don't have the drugs here. What's going to happen with that problem?
I don't know. I don't know if they need to find a new drug manufacturer or what. I mean, I'm definitely against the death penalty, but for those people in the state of South Carolina who are, I mean, you're waiting on the drug to come in and it's not available. So everybody's saying, I heard you earlier, you said somebody's been on death row 35 years. I hope that's not the case, that they're waiting on the drug so they can perform a lethal injection death penalty sentence. I just don't think that doesn't sit well if you're just waiting on a drug, sir.
Yeah, they've always got the option of the electric chair, but I think if you're smart, you make no choice or you choose lethal injection knowing that there is a practical problem in carrying out the sentence using that process, because I think Sparky probably still works there. They just haven't used it in very many years, but they're still allowing that as an option if the convict would like to go that direction. So you've been following this case. You've heard the horror stories, the victim impact statements. You know the facts. Is there, in your opinion, a better case? I know people are against the death penalty, and I get that, and I appreciate that. But as we look at things as attorneys, we know the law. It has to be applied even if we don't like it. Is there a better candidate for the death penalty?
If you have to believe in it, I don't think there's a better candidate. I think Mr. Jones here, I mean, you're 5 minor children who were helpless. You're supposed to love your children and take care of them. You're not supposed to murder your children. And you're strangling your children, 5 of them, the youngest being 1, the oldest being 8. I don't think there's a better candidate here.
Yeah, I think this is the kind of case that challenges your prohibition against the death penalty, because nothing you do to this guy is going to even things out. There's no doubt about that. And I'm sure those who are against the death penalty feel that would make a 6th wrong. And I get that. So we'll see what this jury happens to do with the process. Again, that's the decision. We're on death watch in that case. So let me ask you this. We're going to delve into a number of cases today. Were you surprised? I know I'm going a little far afield here, but we'll get to the Delgado case in a couple of moments. Were you surprised how quickly the jury came back in the Brenda Delgado case? You've been following that. So what do you, I mean, 20 minutes? Are you kidding me? Have you seen that?
Yeah, I've seen it several times, and again, that's not a good action for a defense attorney at all. 20 minutes. I've seen some verdicts, 10 minutes, but we kind of knew where that was headed. So 20 minutes. Now they've already made their mind. You have your co-defendants or your co-conspirators testifying against you. It's hard to wiggle out of that. So I'm surprised it took 20 minutes.
Wow, that's pretty impressive. There was only one charge really to play with. So we'll get into that case in some detail. I mean, it happened so quickly. We got to live that over again and see how they got where they did. We'll be back with more on the Law and Crime Network. Stay right where you are. One of 6 witnesses who had something to say during the victim impact portion of this Timothy Jones Jr. trial. Again, the jury waiting to decide are they going to kill this guy or not. Julius Collins is with me, criminal defense attorney from Atlanta. I mean, these are important moments for this jury, but in this particular case, do they need a whole lot more to convince them that death is the right decision? I mean, if you believe the death penalty is appropriate in the bigger sense, is this going to put you over the top?
I don't think, actually, I do think it will put them over the top. I know, hey, you've got 5 minor children who have already been murdered by their father, but now you start looking at the aggravating circumstances, and you want to piece together a timeline as to how long has this horrible treatment been going on with these children. And the kindergarten teacher is talking about a time when the minor child had thumbprints, choke marks around his throat. I just think it's another, hey, let's make sure we nail this guy to the cross. Let's give the jury something to hear about the treatment towards his children. This is the same guy who claims he loved his children, but would he choke him and would he hurt him? So you definitely want to go the extra mile and add those aggravating circumstances in.
Yeah, I get that. That makes sense, because if there's even one person that is sort of on the fence and now they see this history of mistreatment, that might be just enough to make them go along with that penalty. Remember, it has to be unanimous. There's no doubt about that. That's been clear with the Constitution and the Supreme Court for some time now. So the key, again, has been Natan, the 6-year-old, and we just heard from his teacher. But if you listen to what the defendant himself said, this is in a police interview with the defendant talking about Natan, what he did that day, and how this whole horrible evening carried out. So there's the defendant talking to authorities early in the investigation. And when we first heard that, it was early in the trial. I think we kind of knew that this was going to be one heck of a story to tell. And it's unbelievable that we heard what this defendant say as he said it really almost nonchalantly. Remember, insanity was the defense. Julius Collins with me now. You're the defense attorney now for this gentleman here. Did you have anything other than insanity that you might have used?
I probably would have used the art of persuasion to convince him to take a plea. I mean, once you hear that testimony, not the testimony, but the interrogation, it almost takes you away from a possible plea of insanity, because he's understand what he's doing, he understand it was wrong, and then instead of, admitting to the crime, he kills the remaining 4 children. I don't think that's insanity. I think that was just played up to come up with a defense. And hopefully he wouldn't get the death penalty. But I do not buy the insanity defense just listening to that interrogation.
Yeah, and of course, neither did the jury. In fact, it sounded more like a motivated plot plan to get the heck out of here and save my skin, because I know what I've done is wrong.
Mm-hmm.
So let me ask you this. So if that's the best the defense has, maybe they don't do a plea because they're unwilling to take the death penalty off the table. What do you think of that?
Hey, it's a situation where you roll the dice. It's almost a difference between life without and life without possibility of parole and life with possibility of parole. If that's the plea, then you got to let a jury decide that. So I guess they just wanted the jury to make a determination as to whether or not they would have give him the death penalty in this situation. But just listening to it, I'm almost certain I would have tried to get the death penalty off the table and took a plea, because it's almost guaranteed he's going to get the death penalty.
So I think his only hope to avoid the death penalty is just one person not going along with it. What are your thoughts on whether it's likely or not in this case?
Very unlikely. Once you hear all the aggravating circumstances, you listen to his confession is worse than the actual aggravating circumstances, because he knows exactly what he's doing. And instead of just admitting to the crime and facing the punishment, he chooses to kill the remaining 4 children, and he even admits that, hey, I'm a horrible criminal. I know I'm going to get caught. Okay, well, turn yourself in. You don't kill the remaining 4 kids. Yeah, so it's very unlikely that he doesn't get the death penalty.
And I think you're right, and we'll find out. The jury is chewing on that now. One of many of the cases we're following, including, stand by, Julius, we're going to turn to another case that just resolved today in terms of the jury verdict. Quickly it was done, the Delgado case. We're going to talk about that when we come right back to the Law and Crime Network.